always an honor to rise in this House to speak to the bills that are before us. In particular, Speaker, we're speaking about Bill 157, Enhancing Access to Justice. I want to begin summarizing the sweeping changes of issues that this bill touches for the Ontarians whose heads might be spinning when they read about the bill. There's 19 schedules. It's quite broad. I'm going to say right now that the theme that connects my concerns about this bill is my disappointment that we have before us a bill that touches on so many issues while simultaneously failing to meet the moment for so many of those issues that this bill plans to address. This bill is like using a teaspoon, Speaker, to shovel your driveway when what you really need is a snowblower. Otherwise, you can't get your car out of the garage. At this rate, we will probably get Rihanna's 6th album before we get real action to fix Ontario's broken court system and realize justice from this government. In my speech, I want to outline what needs to change to enhance access to justice, to share what Ontario stakeholders have been asking us to do on a host of issues this bill comments on, from improving cannabis retail to protecting survivors of sexual violence, to fixing the courtrooms and the administration of justice in this province. The theme that can tie us together is that this government's bill is potentially passable without being praiseworthy. Speaker, as the critic for the Ministry of the Attorney General, I take my responsibilities very seriously. And I've met many important stakeholders at Queen's Park and in the community. Stakeholders from the legal and adjudicative tribunal community, unions that represent workers in the corrections, law enforcement, and court systems, victim services groups, gender-based violence sector, human rights organizations committed to honest government and upholding our democracy, small landlords and tenants, and countless others. I've accepted their invitations to attend meetings, AGMs, events, workshops, and conferences, and I'm so deeply grateful for the warm welcome they have extended to me since my appointment to this portfolio. They've had so many different opinions to share. Each and every single one of them want to improve access to justice, and in addition to my staff's excellent note-taking, I've kept all the communications. Speaker, my presentation today is largely based on those meetings and conversations. It is my intention to bring their stories, their voices, into the legislature to help unpack all that is in Bill 157. Therefore, I want to open my remarks with Schedules 6 to 9 and 18. I believe they're very substantial and worthy of further debate. My enthusiasm will be focused on rolling up our sleeves, Speaker, and getting to work to fix our broken court system. Let's set the stage for why these reforms need to happen, including the appointment of judges and aspects of our legal system. Ontario courts and systems for administering justice are in full-blown crisis, and all members in this House know that changes are needed. Ontarians are repeatedly telling us they're losing faith and that our justice system is not working. People are being released from detention centers and jails without the support to be integrated back into their communities, and certainly without a pathway of housing. And innocent people are getting hurt. Public safety is being compromised because there is not enough resources in the courts to properly screen to ensure that people at the high risk of committing violent offenses, again, are being detained not long enough, and those at low risk are being detained for far too long. Police officers and other emergency service workers are being put in the path of unnecessary risks. But we can't fix our crisis in the courts by tinkering only on the edges. Having faster judicial appointments and a better system for coordinating federal and provincial family law is laudable. But it doesn't come to meeting the moment in this bill. Again, Speaker, this bill is potentially passable without being praiseworthy. I want to share a story from my riding of Toronto Centre about the crisis in the justice system. It is the crisis that this government is attempting to address, Speaker, without actually doing the real work to address it. Toronto's very new expensive downtown courthouse was sold to the public as a means to expedite trials and to increase efficiency. Instead, due to this conservative government's failure to adequately staff the courthouse, there have been over 300 courtroom closures over a 6-month period this year alone, Speaker, including 18 courtroom closures on a single day. What's more, workers have been injured at the downtown courthouse, including one who was seriously hurt when brand new shelves fell down and caused the worker to be hit on the head with metal and boxes. OPSU, the union that represents court workers, wrote to the Premier and this Attorney General in 2021 to warn them of the health and safety risks associated with the new courthouse. Speaker, anyone who can read this bill can see for themselves that the government has put absolutely nothing in Bill 157, not a single word to address the staffing crisis in the courts. There's nothing about clearing the backlogs, hiring or retaining court staff required to keep those courtrooms open and processing trials quickly. I'd like to give the government the benefit of the doubt and recognize that Schedules 6 to 9 aspire to improve various court functions more smoothly and efficiently, but setting aside those issues contained in those schedules, these schedules, unfortunately, don't go far enough, and they won't actually help Ontarians waiting in line for justice. It will not get to see that their court hearings will become scheduled faster. Speaker, we have been talking about access to justice and the failures of the government as of late. And we are definitely in a crisis, Speaker. And I think about this crisis often. And I keep coming back to a story that haunts me. Emily, a young woman who was sexually assaulted in her home, who bravely took her rapist to court despite how difficult it was, only to have her court case delayed again and again because of closed courtrooms, until it was finally thrown out, Speaker, because it passed the 18-month timeline. She bravely spoke to Abby O'Brien of CTV News, and I want to directly now quote from this article. On November 17th, a sexual assault charge laid by Toronto police against the man that Emily reported raped her in January 2022 was stayed, and the case has now been thrown out. The court documents will show. In her words, Emily said, "I crumbled. It took so much even to do that first step of giving my statement to the police and going to the hospital. Then a year and a half later, I decided to go back to Toronto to do this trial, face this man, and tell my story. Now it's over." Emily's experience is no anomaly. Under the Criminal Code of Canada, anyone charged with an offense has a right to a trial within a reasonable time frame. Barring exceptional circumstances, that time frame, Speaker, is 18 months in the provincial courts of Ontario. Staffing issues at Toronto's newest Court of Justice, however, have shown delays in courtroom closures in some instances where cases are being thrown out. The courthouse located at 10 Armory, not too far from here, Speaker, opened in February, taking over the proceeding of 6 Ontario Court of Justice facilities in Toronto, a move that the union that represents many of those courthouse workers warned would cause hardships for both staff and those who were in the system. In his decision released on November 7th, Judge Brock Jones said, "This case should serve as a chilling reminder that this is an inexcusable state of affairs, and it must never be allowed to happen again. The emotional trauma associated with never knowing the outcome of a case on the merits will often be long-lasting and severe for both victims and the accused person," Jones wrote. The judge identified the staffing shortage as the reason for the delays in the trial. "There's no reason this case could not have been completed had the courts been properly staffed," Judge Jones wrote. "It is deeply unacceptable that this happened. Emily and the judge have said it all. But this is far from the only time a very serious criminal case was thrown out in the courts due to delays." I'm now going to share another article from CTV. And this article involves a second criminal case, Speaker, and the sexual assault of a minor. It's one of the latest cases to be thrown out of Toronto's newest courthouse due to the, quote, staggering number of courtroom closures fueled by staffing shortages at the facility. In September 2023, charges were stayed against a young person, identified only as CL, accused of sexual assault of another young person. The charges were stayed due to the closures of the courtroom. CL's trial was scheduled for March 23rd, the decision read. But 4 out of the 12 courtrooms were closed that day, and only 15 minutes of court time could be allowed to be allocated to the matter. The next day, on March 24th, 5 of the courtrooms in the building were closed, and the matter could only be addressed for 1 hour, Speaker. The trial could not be completed in the given time and was adjourned till July. At that point, it had now been over 2 years since the charges had been first placed on CL, citing his charter right to a trial within a reasonable time. Recognizing it had been breached, the youth applied to have the charges stayed, and an application granted in the court in June. Can you imagine, Speaker, experiencing a sexual assault as a minor, going through the legal proceedings that took 2 years, and then having the whole thing thrown out because of delays that this government could not have been doing enough to prevent? This is the stuff of nightmares, and this is why I'm staying up too late. I recognize it probably keeps a lot of people up in Ontario. Speaker, another criminal case was thrown out in September, this time a charge involving impaired driving. The case was called the tip of the iceberg, unquote, by Justice Advocate who spoke about it. Schedules 6 to 9 are inadequate to address the iceberg of the backlog cases. And thank you to the excellent reporting from the Toronto Star, and in particular Jacques Gallant, we have the excruciating details of how this impaired driving case was thrown out. Ontario Court Justice David Porter, who stayed the impaired driving charges, said that the staff shortages have continued on a daily basis, resulting in courts being closed almost daily, thus preventing cases scheduled to be tried from proceeding. The Crown provided no evidence of what, if any, extraordinary measures have been taken to address this urgent issue. During the week of September 4th, 14 courtrooms were closed. On Thursday, 15 on Wednesday, 6 on Tuesday, the Ontario Court of Justice told the Star. And due to the staffing shortages, about 1.5 hours of court time could be used for the first day of the 2-day impaired driving trial this past June, Judge Porter wrote. The trial was supposed to continue the following day, but had to be adjourned until October because of the lack of staff, and the assigned courtroom was closed once again. Justice Porter noted that the delay between the original trial date and the new dates is solely contributable to the actions of those responsible for the administration of the courts, unquote. Alarm bells have been ringing since the new building started hearing cases. Before delivering a judgment in April, Justice Brock Jones said in court that the burden on the staff is the greatest it has ever been, and they are often expected to work well past regular court hours. The Justice said, they need and deserve the level of resources and support required for them to do their job properly and to reflect on their professionalism and dedication to the administration of justice. The Justice said, they are the backbone of this courtroom. We cannot function without them. The only way that we can begin to make things right for Emily, CL, and all the other survivors and victims of crime who've been denied their day in court, Speaker, is to make sure that no other survivor or victim experiences the indignity of having their cases thrown out due to avoidable staff delays. So what solutions will help Ontarians schedule their court hearings faster to avoid these tragedies? Solutions that should be in a bill entitled Enhancing Access to Justice but unfortunately are not. Solutions that should include the hiring of enough support staff, clerks, court reporters, trial coordinators, judicial assistants, etc. We need to bring all those levels up. We need to reduce the strain on staff and to keep all and every available courtroom open. Solutions that increase pay to incentivize the court staff to stay, because recruitment is not enough, Speaker, if we don't retain them. This government has failed to adequately staff Ontario courts, leading to the dismissal of serious criminal cases, including the allegations of sexual assault. The Attorney General claims that the ministry continues to recruit and onboard staff. Still, the union that actually represents those court workers, OPSU, has countered by saying any new positions that have been created barely scratch the surface of the staffing needs, as many experienced court staff were lost during the amalgamation of those courts. Why is there nothing in the 19 schedule, Speaker, in Bill 157 to address the hiring and the retention of court staff to prevent further court delays? This government could fund and commit to funding existing renovations in the courthouses, or to build new courthouses in regions where there is not enough infrastructure, but they've chosen not to, Speaker. Speaker, you'll recall that in 2020, this government cancelled plans to build a new courthouse in Halton County 1 month before construction was due to start. And after that project was cancelled, the Halton County Law Association wrote to the Premier and the Attorney General highlighting the myriad inadequacies and the chronic dysfunction in the existing Halton courthouses. I heard concerns from lawyers and court workers when the Federation of Ontario Law Societies visited us here. Since the project was cancelled, courtrooms in the existing Halton courthouses have been closed for technology failures, broken AC units, mold, asbestos, and gas leaks. One trial should have taken 1 day, was delayed for over 1 year due to issues with the Burlington courthouse. The judge in that case called it, and I quote, embarrassment for the people of Halton, Speaker. When this bill goes to committee for public input, where amendments will be tabled to strengthen and improve the bill, it would be wise for the government to consider amending 157 to reverse its decision not to build a new consolidated Halton courthouse. The court system can be modernized with additional amendments at committee. It could implement, Speaker, a province-wide standardized technology platform for scheduling, filing documents. The government could increase training for judges, justices of the peace, and support staff in conjunction with standardizing this technology use. But, Speaker, I would be remiss to not touch on the most important action this government could take to table a bill that lives up to its name of enhancing access to justice, and that is increasing the funding to legal aid. Bill 157 makes changes the government hopes will help clear some court capacity. But, Speaker, if you want to free up court resources, you need to reverse the cuts to legal aid funding. The government has cut legal aid funding to Legal Aid Ontario by $133 million in 2019, and this year their underspending is funding to Legal Aid Ontario by $103 million. It is well known that self- and underrepresented litigants lead to extra court time and cause delays. All of the delays I have mentioned have been exacerbated directly or indirectly by a lack of legal aid funding. So I wonder whether or not the government will consider amending Bill 157 to reverse its devastating cuts to legal aid. It is well known that self- and underrepresented litigants lead to extra court time. So what's the solution, Speaker? It's simple: funding legal aid. Legal aid pays for itself, Speaker, in shortened court time, smoother processes, and the unquantifiable quality of life gains for Ontarians who need legal representation but cannot afford it. These cuts, Speaker, are not money-saving. They just push the costs down the line, creating massive inefficiencies. Bill 157 is not living up to its aspirational title. Currently, Speaker, a single person without dependents who earns less than $18,975 a year in gross income does not qualify for will only qualify legal aid. Anybody earning over $18,975, you're out of luck. Let's juxtapose that, Speaker, with what a CERB recipient would earn in a single year, which was deemed a living wage without having to pay for court costs. And, Speaker, you'll recognize that that amount, $18,975, is significantly too low. Speaker, a member of the Federation of Ontario Law Associations was sharing their thoughts with me on how to modernize access to justice in Ontario, and I want to quote, "We're concerned about the financial cutoffs in terms of whether people are eligible because there is such a gap between the top-level limit of eligibility for legal aid and people who are unable to afford a lawyer. We have major areas within the province where no one is able to access their legal aid certificate." I want to read this again. We have major areas within the province where no one is able to access their legal aid certificate. And that's a huge problem for us within the clinic system. We also in the clinic system have funding issues because of inadequate compensation. We're having a great deal of difficulty maintaining staff. So without continued adequate funding going into the system, we're really undermining the administration of justice, particularly for our low-income residents. Another lawyer told me, one of the things that I'm hearing a lot from members is that a great deal of the backlog and wasted judicial resources in the system comes from the high turnover rate that we are seeing. It's difficult to maintain staff who have experience, who are more efficient in particular areas. So I encourage you in your efforts to look into that, they told me, because I know that it has been impacting my practice, said the lawyer, and the practice of others that I represent. Speaker, lawyers from all over Ontario are in agreement. Our legal institutions need better resourcing and the funding to retain highly qualified and experienced staff to deliver the quality of service that Ontarians expect and deserve. Speaker, like me, you may be wondering if this government would consider amending Bill 157 to change the threshold to access and increase legal aid funding. In fact, Speaker, the minister's remarks yesterday in his one-hour lead, he spoke about how this bill plans to advance the government's so-called digital-first approach to the courts. And let me be clear, we need to bring our courts into the modern age. I'm a huge advocate of doing that. But a digital-first approach to justice should not mean a digital-only approach to justice, Speaker. The rapid shift to digital hearings has meant many vulnerable people across Ontario are not being able to access justice, and this government knows it to be true. The Ombudsman of Ontario's report earlier this year was absolutely scathing on this point. Speaker, it found that a digital-only approach presented, and I quote, "It created insurmountable challenges to Ontarians struggling to access justice." And Speaker, there is a deeper warning in this example because the Landlord-Tenant Board's digital-only approach has made the backlog worse, all-time historic high. Tribunals Ontario published their annual report at the end of June this year and showed an increase in case backlog from 34,731 cases in March 31st, 2021 to 53,057 cases in March 31st, 2023. The backlog got bigger. Digital first is a great soundbite, but a useless talking point, Speaker, when Ontarians have to wait longer than ever to access justice. Speaker, we have to keep going because this bill is enormous. So what else does it do? It amends rules governing the Judicial Appointments Advisory Committee to remove the requirement for the Judicial Appointments Advisory Committee to consider cultural identity as a statistic for judicial candidates in their annual report. This committee considers, interviews, and recommends judicial candidates to the Attorney General. They are meant to be independent, arm's length, as a committee. Their role is under strain, Speaker, and the committee's experience benefits all Ontarians. It helps to ensure that we hire the very best judges. This committee is required to produce an annual report on judicial candidates and to include statistics on the sex, gender identity, sexual orientation, race, ethnicity, cultural identity, as we know is being struck out, disability status, and the ability to speak French of candidates who volunteer that information, including whether the candidates identify as an Indigenous or as a member of the Francophone community at each stage of the process. This change builds on the Government Bill 256 tabled in 2021, where it increases Cabinet's influence over the committee by increasing the number of committee members appointed by the Attorney General. Increasingly, though, and interestingly, I should say, the committee is required by law to produce an annual report. It has not produced an annual report. Not in 2019, no report in 2020, no report in 2021, and no report in 2022. When reporters FOI'd the reports, their request was denied with an explanation, quote, "A search was conducted and no responsive records were located." So how does this help, Speaker? When the Attorney General is failing to even produce this report, how does that ensure that the government's meeting its own standards so that the government can effectively fine, hire, train new judges? I'm very deeply invested in the success of the judicial system. It makes our democracy work. But it's also deeply concerning, Speaker, when the government doesn't want the public to know basic statistics that they are supposed to report on, that reporters can't gain access to so that they can do their job. It makes me wonder, Speaker, why the government is doing this. And I simply don't know. What I do know, Speaker, and I think we all do because we've heard it in an interview on TVO, is that the Attorney General wants to see more judges that share his values. Is that the aim of this? Is it possible that government fears a report showing that the recommendation list is becoming more male, more pale, more stale? And that might be embarrassing for them. I don't know, Speaker, because we don't have the report to show us otherwise. This government has politicized Ontario's judiciary by increasing the Attorney General's influence on the Judicial Appointments Advisory Committee and on the filling of judicial vacancies. Judicial independence is a core value of the justice system, and I think that this government would be wise to consider amending Bill 157 to remove the Attorney General's influence over the judiciary. This government has given itself more influence over filling judicial vacancies, ostensibly to make the process move more quickly. However, the City of Cornwall has had a criminal judge vacancy for close to 2 years. And thanks to the Attorney General rejecting all the recommended candidates, they still sit without that justice. Maybe it's changed. I'm not sure. Will the government consider amending Bill 157 to create a statutory timeline to make sure that no other community goes without a judge for such a long period of time? Additionally, Bill 157 amends Ontario laws to remove the Chief Justice of the Ontario Court of Justice from the Civil Rules Committee and to allow the Chief Justice of the Superior Court of Justice to appoint an associate judge to the committee. Additional amendments to this bill would require that all records and other information collected, prepared, maintained, or used by the Ministry in relationship to the business of the Civil Rules Committee and the Family Rules Committee is not be disclosed publicly unless authorized by the Attorney General and excluded from the application of the Freedom of Information and Protection of Privacy Act. What does that mean? Well, Speaker, the Civil Rules Committee and Family Rules Committee have broad powers to change the rules of practice and procedure for those courts in all civil proceedings and family law proceedings. The rules can have a huge impact on legal proceedings. If you miss a deadline, if you file something not in accordance to the rules, it means that you are barred from legal remedies. My office recently worked with a constituent, and they're still working with a constituent, my staff are still working with this constituent, who missed an arbitrary deadline in a hearing when they had to file something in order for them to get their appeal. It was devastatingly time-consuming for this low-income, racialized individual living in social housing to navigate this process on their own. I won't use her name, Speaker, but this is the kind of court error that made work for my office as we tried to help a vulnerable person navigate a system. Without knowing more about why this is happening, it's concerning that the government is suddenly trying to make documents and information about changes to the civil rules and family law rules secret. Speaker, it only reinforces the question, why? Why can't the public know about information and documents that are being considered? Who is sending the information the government doesn't want us to know about? What is the advantage, Speaker, of keeping our justice system's rules secret? And how does this lead to fairer, better, and faster trials? I'm not seeing the path, Speaker. Further amendments to Schedule 6 would allow that when a judge presiding over final order in child protection and extraordinary measures are involved, which, as we all know, can mean mental health treatment, including admission to a secure facility, an adoption licensing hearing is appointed to another court. That judge continues to have jurisdiction to complete the hearing and provide a decision. Now, Speaker, this sounds like a great idea. Bringing in a new judge at the final order stage of a proceeding would almost certainly add more time and expense to the proceeding to allow the new judge to learn the file. I applaud the government for finding this minor efficiency and taking this step. But what I don't see, Speaker, is why only allowing this during the final order stage of proceeding. Why not say in all stages except the preliminary, or something to that effect? It would seem better for the judge, the same judge, to preside over the majority, if not all of the proceeding, to reduce court time and expense. In all of our constituency offices, we assign workers to each constituent, as much as possible so that constituent can have a seamless experience when receiving service through our office. They don't have to re-explain their situation to an undue number of times. It is common sense, Speaker. Why don't we extend that same common sense and reasoning to the court systems in a way that allows us to go deeper and faster to ensure that Ontarians have access to justice? And since I'm talking about efficiencies, why not centralize a single case's court proceedings to one judge as much as possible? I have another recommendation, Speaker. I've heard from many stakeholders that are having difficulty through the family courts in Ontario. There are significant inefficiencies, and there is a way to make it all much smoother and less stressful for families, Speaker. Family law matters experience judicial overlap between the federal and provincial courts, forcing families to move between two systems. They have to interact with two different court systems. I think that we can imagine that it is inefficient, and it's certainly been confirmed by many who work in the system. It is emotionally and financially draining. It is a process fraught with difficulty. There are 25 court locations in Ontario with unified family courts, but there are many more locations without it. Why don't we unify all of them? Especially since the federal government has provided funds to expand the unification of family courts, and the funding has been available since 2018. We have no reason not to do it. This is the kind of substantive change that I would have liked to see in this bill. Speaker, I strongly believe that this government could have gone even further in reforming family law to make it work for Ontarians. We can review and appropriately expand the number of dispute resolution offices so that fewer matters go to court in the first place. This would save taxpayers money and Ontario families the expense and grief of unnecessary court proceedings. Speaker, I'm going to move to Schedule 18. This schedule is supportable, but following the theme of my remarks today, not praiseworthy. It's a small change that allows victims of certain prescribed crimes, and they are sexual crimes against minors or those with a disability when the crime took place, human traffic-related crimes, and crimes that would have colloquially been described as revenge porn crimes, will have one less section to fill out in their affidavit or filings in civil court, because the emotional distress is now presumed to have occurred for those crimes. Simple change, good change. The process should be straightforward so that survivors don't have to relive their trauma again and again and again. I heard from a lawyer in the sector who said, I think it's generally a good idea to broaden the ability of survivors to sue for the harm that has been done to them. End of quote, Speaker. But, again, the bill could go further. It's not a big win. It's a small procedural change that will benefit a very small number of victims. Victims who are minors, those with disabilities, those who have been trafficked are less likely to have time, resources, and the money to go through civil courts. So how many people will this substantially help? This is another case of the government taking a tiny step, making a tiny change, and calling it a big win for survivors. Still, at the same time, they are slashing legal aid budgets. And Speaker, let's remember that in 2019, this government ended the Criminal Injury Compensation Board and replaced it with the Victim Quick Response Program Plus. The Victim Quick Response Program Plus isn't available to victims when they can access public programs, even if those programs have months-long wait lists. I heard from a constituent of mine who is a lawyer who said, and I quote, "It is deeply hypocritical of this government to dismantle the Criminal Injury Compensation Board, but continue to do things that allow them to make announcements that make it appear like they support survivors as a core value. There are actual substantive changes that they could enact to better the lives of survivors of violence, but they won't touch those." End of quote. Will the government consider making amendments to Bill 157 to increase access to the Victim Quick Response Program Plus? That would be supportable, Speaker, because that would mean that the government's doing much more. They could also properly fund the Ontario courts, coming back to my main point, so that sexual assault cases aren't dismissed for delays over and over and over and over again. They could also fund, Speaker, this government can fund sexual assault support and rape crisis centers. Because, again, this government in 2020 decided to stop renewing its annual $1 million in funding to boost rape crisis and sexual assault support centers. Some of those centers, speakers, are now seeing the longest wait lists they have ever experienced. Those sexual assault centers, rape crisis centers, those workers have warned that wait times act as a deterrent for victims because victims will stop trying to access services because they've been told to wait. Speaker, in Bill 157, the government can actually increase funding to rape crisis centers and sexual assault centers to truly support survivors. It is well studied that impoverished, low-income people are overrepresented in the criminal justice system. This government is sitting on billions of dollars of contingency funds. Why not use some of that money to support survivors and victims, instead of punting and punishing those disproportionately impacted, impoverished people? Another consideration, Speaker, is what extent are victims re-traumatized when they have to go to court, which is very expensive to access and very timely to access, to go tell their story again in civil trial? And how is there any guarantee that that case is also not going to be tossed out because of the extraordinary delay in the courts? More so than a small change that Schedule 18 makes, Speaker, this bill could also go further to support survivors by incorporating my private member's bill, Stopping the Misuse of Non-Disclosure Agreements Act. We've heard about stories in the media about the perpetrators of violence and abuse, those who are powerful and wealthy, both individuals and institutions and corporations, who have used non-disclosure agreements to silence survivors of sexual violence, bullying, and intimidation. The latest stage of criticism comes out of the Me Too movement, details of the alleged and proven abuse, and then later legal actions surrounding Harvey Weinstein, Bill Crosby, Olympic coach Larry Nassar have highlighted the role that these clauses within the NDAs play in silencing survivors. Closer to home, Speaker, we had NDAs used here in Canada in the Albert Schwartz case to silence survivors. It was revealed that Hockey Canada paid out $7.6 million in 1989 in several sexual assault-related settlements, and non-disclosure agreements bound some of those claimants involved in the settlement. There are growing calls to outlaw non-disclosure agreements across the country as Hockey Canada and other sports organizations reel from the sexual assault scandals, including some that have led to multi-million-dollar payouts to keep details about those incidents secret. If the government had incorporated, feel free to lift it right from the bill, if they've incorporated the aspect of that bill to stop the misuse of NDAs, they would prohibit people in the positions of power with money, privilege, and access to stop re-abusing survivors. Survivors could request other types of agreements, such as a one-sided confidentiality agreement to protect their own privacy, should they choose. NDAs were used by perpetrators to cover up sexual and physical violence, workplace harassment, wrongful dismissal, and many other situations of discrimination that individuals, workplaces, and other groups would rather not deal with. The misuse of NDAs also perpetuates patterns of harm and abuse. When survivors can't speak out in warning or to affirm to others that they aren't alone, harm continues, Speaker. Influential people use power while those who have so much to lose will lose. There's a website entitled Can't Buy My Silence. They contain heartbreaking stories of people who've suffered greatly before and after being presented with an NDA. And they also include people who've chosen not to sign. and they were denied the financial compensation they deserved for their suffering. And no one should have to decide between the two, taking away their voice or taking away their compensation. That, Speaker, would help survivors. That, Speaker, could easily be put in Bill 157. I want to share another relevant story, Speaker. In early November, I attended a panel by the Criminal Justice Association of Ontario. They brought together stakeholders in criminal and justice and youth justice to discuss what changes frontline workers needed. I was particularly struck, Speaker, by stories from the youth justice centres. Those centres work with youth and provide them and their immediate families counseling and support. Recognizing that perpetrators of violent crimes are oftentimes repeating cycles of violence, they continue to provide counseling and support to violent offenders to rehabilitate everyone in their community and to invest in preventing violence at all costs. That was good work. It began under the previous government. I was a sitting councillor at that time when the ministry came to me to provide a briefing of what this facility would do and how it would impact and support my local community. I was supportive then as a local city councillor. I remain supportive now. This is the kind of creative, innovative approach that we need to see more of. That, Speaker, is good work. And it's been carried forward by this government. And it should be expanded as quickly as possible so it can be accessed across Ontario. Speaker, people who commit violent crimes and sexual violence will still need to live in our communities, whether any of us like it or not. That's just a reality. People are not disposable. We need to ensure that they have real pathways to rehabilitating the whole person so that they can come back into the community and be fully integrated, and where the community and that person who committed harm can be safe. This government loves to take away the whole pie and then throw back a few crumbs. Now, Speaker, I'm going to move on to a few other schedules, because I do need to provide comment on them. Some of them are straightforward housekeeping schedules, and I won't speak too much about those. But I will speak about Schedule 1, the Architects Act. This schedule has been quite controversial, Speaker, as you know, and I hope that at committee we can gain a much better understanding about Schedule 1 and the decision that was made leading us to Schedule 1. I've heard arguments from the Association of Architectural Technologists of Ontario, the AATO, and the Ontario Association of Architects, OAA, on this licensing. They are not in agreement. One is much bigger, more members, more money. One is smaller. The government has chosen through the schedule to side with the OAA. I would like to know more about how this government came to this decision, what conversations were had, who said what to whom, and how, the rationale that was used to arrive at the decision. I would encourage the minister to meet with the Association of Architectural Technologists of Ontario and to meet again if they already have. I've met with them. I've heard their following concerns. The OAA made an error when they went ahead and created their own class of architectural technologists by way of a policy, even though the Architects Act requires you to do this through regulation. AATO took OAA to court, and it ruled that the certificates that the OAA issued were void because they were formed under a policy, and this was made under a consent order. AATO met with the Ministry of the Attorney General, asked them not to make the very changes that they are now making in Schedule 1, which they see it as now rewarding bad behavior, because even the court ruled in their favor. It's really unclear to me, by reading Schedule 1, whether or not this change is retroactive, because we need to know that, as it will have significant implications in the bill. Speaker, I'm concerned about the implications of setting the wrong precedent on the matter. Regulatory bodies are entrusted with incredible trust and powers of self-governance. We have many of them in Ontario. Every single member of this House knows that self-governance is supposed to impose higher standards, not lower standards. Every self-regulating profession has to prove to Ontarians every year that they deserve the trust to legislatively invested in themselves. Speaker, the Ontario Superior Court of Justice found that the self-regulating profession did not live up to its own standards. The consent order was made that a regulatory body issued licenses that were clearly outside of their scope. Speaker, giving a professional body that broke trust everything that it wants is setting a dangerous precedent. We want Ontario's regulatory bodies to respect their boundaries. We want and embrace that professions will change and that professions need to be modernized. And absolutely, Speaker, they should. But when a profession puts the cart before the horse, or in this case, accepts licensing fees for something they are not legally entitled to license, why are we rewarding them when the power that they have broke the trust that they were given? I need to stress, Speaker, people paying licensing fees went through training, but their trust was betrayed. And Speaker, I am additionally concerned and eager to learn about how we can ensure that there are appropriate differences between architectural technologists and licensed technologists, because I'm not sure if I see the clear difference in this bill. And what I want to point out, Speaker, is that there are contradictory and overlapping regulations and red tape. I hope that this government isn't about to saddle Ontarians with the needless confusion and additional red tape. Speaker, I hope this government continues to consult with these stakeholders and considers their input when this bill gets to committee. Speaker, Schedule 2 and 3, Cannabis Control and Cannabis License Acts. Who's asking for these amendments? Because when the minister was asked by the press about the provision prohibiting the growing of cannabis in childcare facilities, except for home childcare facilities, and specifically are there instances of this happening, the minister was not able to provide any examples. Speaker, the harm that comes from cannabis oftentimes happens when an underage person consumes an inadequately labeled product. The cannabis plant and its leaves do not leave bioavailable THC. Cannabis buds need to be processed and cured before they have any psychoactive effects. Unprocessed cannabis plant leaves are not more harmful or psychoactive than any other random plant that can be found around the house or in a daycare setting. None of this is to say that is necessarily bad regulation, Speaker. It's just the concern of how did we get here. Cannabis plants have the intense light requirements indoors that can be potentially harmful for developing eyes. Moreover, the lamps cannabis plants need can get hot, Speaker, and for that reason, we want to protect the children's hands from open stoves. We want to limit opportunities for children to burn their hands on these bright lamps. But Speaker, when listening today, or yesterday I should say, the government, I didn't get the sense that the government knew this. Is the schedule here before us because children have been munching on plant leaves and they've gotten high? I don't know, Speaker, because the minister couldn't give us any examples. The government can do much more to keep children in childcare safe, and more likely by providing more funding for more inspections. This government can ensure that childcare providers earn a decent wage while experienced providers in the profession in the long term develop deepening quality of care for our children, to provide workers with stable careers so that they can stay where they want to stay. I do, however, want to comment on the kinds of reforms through enhanced community safety that can be accomplished through cannabis regulation. First, Speaker, let me be clear. When cannabis harms do come about, they are oftentimes from the illegal markets, and the regulations surrounding cannabis and making it impossible for legal cannabis to compete. Legal cannabis companies have to pay taxes through production and the sales process, and like any other industry, we understand this need. And this unique sin tax imposed on the cannabis industry means that we're not going to create a level playing field against the illegal cannabis market. Speaking about a level playing field, Speaker, the regulatory changes proposed in the background to this bill are even more controversial. I honestly thought the Premier would appreciate that a diverse and competitive market of many small businesses and cannabis suppliers would deliver the most affordable costs and choice to consumers. This change will promote centralization in an industry that has already experienced enormous consolidation, allowing retailers to own up to 150 stores from the existing 75 stores during a period of industry centralization will allow businesses to take a Starbucks approach and weed out their competition, which could be bad. But here's the rub, Speaker. When I wonder why the government would make such a hoopla about the non-issue, like cannabis and childcare facilities, and then move to quietly advance the centralization and the consolidation of big cannabis corporations by giving them much more expansion power. Speaker, a cannabis market looks like a grocery market, a market that should be competitive but is not, should be innovative that is not, and should be affordable that is not. It's not a market where we compete with illegal suppliers. It is a cannabis industry that stems from the flow of money and gangs, human trafficking, money laundering. It will not make the cannabis industry safer for Ontarians. I'm eager to learn in committee about what kinds of regulations this government and the Indigenous community want to see in the regulation of cannabis on reserve. I would be remiss, Speaker, if I didn't mention that First Nations are a significant stakeholder who live in a geographic area, and they are in the best place, in the best position to understand what their communities need. This government might remember the private member's bill entitled Cannabis Retail Amendment Act, put forward in 2020 by the member of Davenport and now Leader of the Opposition. I certainly do, because I supported her bill as a city councillor, because her bill proposed giving cities a say in the location and distribution of private cannabis locations within their communities. Speaker, it was before my time at Queen's Park, but I can tell you that the New Democrats push for responsible legalization and continue to do so for the legal, regulated retail cannabis industry. This party advocated strengthening the municipality's role in distributing pot shops licenses to avoid a situation where some neighbourhoods had too many while others had none. The previous Liberal government put some restrictions on the cannabis retailing framework after hearing back from children health experts and municipalities like Toronto on how we wanted that program to be rolled out. And I very clearly remember the debate at City Council when we voted to opt into the new cannabis retail framework. Shortly after the Conservative government got elected in 2018, all that careful research, consultation and planning was tossed out without further notice. Toronto had already opted in under a different plan, but they were getting a new one in the rollout. The new plan was blunt and without urban planning refinements and the consideration of the previous plan. Under the Conservative government, cities can still either reject cannabis stores entirely or opt into a provincial framework where they have no say, absolutely zero input where cannabis shops go. Speaker, in this bill, when it comes to further expanding retail cannabis, especially when it's happening without any consultation or notice with cities, I strongly encourage this government to look at the past Ontario NDP bill that will work with cities and empower their business districts to continue, which are still continuing to recover from COVID-19. Speaker, as I mentioned, there are 19 schedules to this bill. And this bill is broad and substantial and far-reaching. And it touches the Coroner's Act, it touches the Fire Protection and Prevention Act, It creates a condition where we want to see more being done to ensure that community members are protected, public safety is enhanced, access to the court thoroughly delivered. It touches the Juries Act, the Justice of the Peace Act, the Land Titles Act, the Law Societies Act, the Legislation Act, the Provincial Offences Act, the Public Officers Act, and finally references to the court. We need to see the court system corrected and fixed. This crisis and access to justice must be addressed. But there's not enough, I should say. There's not enough in this bill to do that, and I'm hoping that we can see more positive changes at committee.
That's time. We're going to move to a question. Recognize the member for Brampton North.
Brampton North, Madam Speaker. Thank you very much. Thank you to my colleague from Toronto Centre for the comments. I listened intently. This is a very good bill that we're putting forward. In my view, the Enhancing Access to Justice Act. A few reasons why I intend to support it are because it's going to be making it easier for victims of crime, such as victims of terrorism, vehicle theft, human trafficking-related crime, and hate crime, to sue it, make it easier for them to sue an offender for emotional distress and related bodily harm. It'll protect children and youth by banning the growth of recreational cannabis in homes that offer childcare services. A lot of other good things in the bill. Wanted to know whether the member across thought these were good ideas and we're supporting. Thanks.
The member for Toronto Centre.
Thank you very much, Speaker. I don't believe that the member was listening as intently as he says, because I did highlight. I did highlight exactly what were the deficiencies in the bill and what I'd like to see improved. It tinkers around the edges and it doesn't go far enough. It certainly doesn't address the challenges and the crisis we have in the court system. As I've mentioned, the central theme of all my remarks today is that this bill is possibly passable but not praiseworthy, and I stand by that.
Thank you. The next question, the member for Spadina, Fort York.
Thank you, Madam Speaker. And I want to thank the member from Toronto Centre. You know, you do an incredible job of representing your community. You're doing a great job here of advocating for access to justice for the people of Ontario. And what you described at the beginning of your remarks was a court system that's in chaos, that is in absolute crisis in this province, with people being denied access to justice. A rape case, a woman who had the courage to bring forward Emily, who had her courage to bring forward her case to the courts, having it thrown out because there weren't enough court staff to keep the courts open. Can you describe, just in some, with a little bit of detail in the time that you have, some of the crisis that's happening and some of the impacts that is creating for people in Ontario?
Thank you. The member for Toronto Centre.
Yes, and thank you to the member from Spadina, Fort York, for his important question. Obviously, we see the fact that criminal cases are being tossed out and charges are being stayed, and that costs time and resources for the court system, the reporters, the lawyers on both sides, the Crown and the trial lawyers involved. What I can quantify, I cannot quantify, Speaker, is the emotional harm that it recreates for those survivors and victims of crime. And that, Speaker, to me is a tragedy, because they never got their day in court. They never will get closure on what happened to them, a very traumatic incident, and not to mention, Speaker, the accused. The accused will have that charge and that report hanging over their heads forever, also without their day in court.
Thank you. Next question. The member for Beaches East York.
Thank you very much, and good morning, everyone. It's a pleasure to be here with you in the morning. And thank you to my colleague from Toronto Centre for that long talk. It's hard to do. And we worked well together at City Hall. We were seatmates for 8 years, and I know how hard you work for your community and all of Ontario, so I appreciate that. Thank you. And just with regard to this bill and your ideas for it's not going far enough, can you give us maybe your top 2 suggestions for improving this bill?
Thank you. The member for Toronto Centre.
Yes, and thank you to the member from Beaches East York. I also have some very fond memories of our time sitting together at City Hall and working constructively and collaboratively on many issues. The top 2 issues that I would like to see in this bill are, and it's easy twofold. One is to adequately staff the courts, to do everything you can in all your powers to ensure that the minimum requirement of time constraints are met. The standard has got to be met. No more throwing out of criminal cases. That is one thing. The second thing, I'll add 3 if I have time. The second thing is fund legal aid. You need to be able to do it. People are being impacted by not having access to the judicial system that they so rightly deserve. And the third is to fix the tribunals.
Thank you. Next question. The Attorney General.
Thank you, Madam Speaker, and there's just so much to unpack there, but I want to start by thanking the member for filling an entire hour on a whole variety of topics. There are things that I heard that are encouraging to me. I heard you say that the Unified Family Court is something that you would like to see expanded. We're on record. The Auditor General has confirmed even a couple of years ago. We're waiting in the federal government, Madam Speaker, and so I would just ask for the member to confirm that they will stand with us in the request of the federal government to expand Unified Family Court here in Ontario, and that is something perhaps we can advocate together.
Thank you. The member for Toronto Centre.
And thank you very much to the Attorney General for his question. And I didn't get a chance to congratulate you on your 1-hour lead as of yesterday. Absolutely, I will stand with the government and every party in this House as we advocate for the unification of family courts. It is unduly unfair to families who are trying to access and navigate 2 systems. It's costly, it's time-consuming, and of course the emotional duress, it just doesn't work. And we have a proven record of it working when we unified, and that's where we should be moving to.
Thank you. Next question. Member for London West.
Thank you very much, Speaker, and I want to congratulate my colleague, the member for Toronto Centre, on her very thoughtful comments on Bill 157. She talked about the changes to the coroner's inquest rules in Schedule 5, and she has advocated, as have I, for the government to implement the findings of the Renfrew County Coroner's Inquest on the murders of Carol Culleton, Natalie Warmerdon, and Anastasia Kuzak several years ago. So my question is, do the changes that are included in this bill, do they require the government to implement any recommendations that may come out of a coroner's inquest? Because we have certainly seen the government refuse to implement the #1 recommendation out of the Renfrew inquest, which is to declare intimate partner violence an epidemic.
Thank you. The member for Toronto Centre.
And thank you very much to the member for that significant question. No, there is absolutely nothing in this bill that speaks to the recommendations that came from the Renfrew inquest. Not only is recommendation 1 from the inquest free of monetary obligations, declaring IPV an epidemic allows us to address it with the same type of urgency. But I would draw the government's attention to recommendation number 4 in the Renfrew inquest, which is to create an implementation framework to make sure that everything in that inquest report can be implemented as quickly as possible. That can go into Bill 157. It would strengthen the access to justice bill. Thank you.
Thank you. The next question, the member for Thornhill.
Thank you, Madam Speaker. Good morning. I want to thank the member for her contributions this morning, but one of the things that I like to emphasize is positive moves within time, and this bill has made changes under the Victims' Bill of Rights, expanding the list of crimes where victims are presumed to have suffered emotional distress. Right now, under this section, that only includes assault by a spouse, sexual assault, and attempted sexual assault. And this is now expanded, or will proposed to be expanded, to include human trafficking and certain sexual offences, including those committed against a minor. So I guess my question to the member is, does the member opposite think that these modifications are a positive move?
Thank you. The member for Toronto Centre for the reply.
Yes, thank you very much, and thank you for your question to the member. I did say in my remarks that it is positive. There is some merit, but it doesn't address the core issues that we have that is failing the justice system. And by ensuring that there is not a requirement to meet the emotional duress, by including those 3 categories, What it doesn't do is actually remove the cost or additional charge and time that a victim of crime would have to go back to court for and have the resource to sue through another civil court system in order for them to access justice. And that's why that section falls too short.
We don't have time for another round of question and answers, so we're going to move to member